Major breaking news out of the state of Illinois. The United States Court of Appeals for the 7th Circuit, based in Chicago, Illinois, Federal Court of Appeals out there, has just stayed District Court Judge Stephen McGlynn's decision that had ruled that Illinois' quote-unquote assault weapon ban and magazine ban, if you will, were unconstitutional. The 7th Circuit has stayed the effect of Judge McGlynn's ruling in favor of the Second Amendment, and as a consequence, all those insane, crazy anti-gun laws in the state of Illinois will remain in effect. I repeat, will remain in effect because the 7th Circuit Court of Appeals 3-judge panel has just entered an order staying, which means putting on pause the federal trial court win in favor of the Second Amendment entered by Federal District Court Judge Stephen McGlynn. We're going to break it all down when we come back, but the bottom line is this is big news, but it's bad news if you support the Second Amendment right to keep and bear arms and the rule of law and our Constitution. And yes, indeed, our buddy Judge Frank Easterbrook is involved with this debacle yet again. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee, as you know, for the 2025 Gunnies Awards in the category of Top Voices of the Second Amendment. Top Voices of 2A. If you're going to be voting in the Gunnies, you can vote every day through the end of this month. Then make sure you vote for Four Boxes Diner Mark Smith for the top voice of the 2A. We've been nominated and a finalist in a lot of categories in the past, have never won one, but this year I feel like we're going to get it done. I appreciate your support, and of course, I always cheer for our friends in all categories who support the right to keep and bear arms and the U.S. Constitution. All right, folks, so bottom line is this. Bad news out of the United States Court of Appeals for the 7th Circuit, which is the Federal Court of Appeals based in Chicago, Illinois, overseeing, among other things, Illinois and other states out there. You may recall there was a week-long trial in the United States District Court for the Southern District of Illinois, the part of Illinois that actually has common sense and respects America, as far as I'm concerned. Federal District Court Judge Stephen McGlynn wrote an extensive, very long, I believe over 100-page long opinion and order explaining why the Illinois quote-unquote assault weapon ban was unconstitutional under the Second Amendment because it banned firearms. They were in common use for lawful purposes by Americans, as well as magazines that held more than 10 rounds. And of course, he had to follow that insane ruling by the United States Court of Appeals for the 7th Circuit, written by Judge Diane Wood and Judge Frank Easterbrook, 2-1 decision a while back, articulating a view of the Second Amendment and how to handle arms ban cases that was totally inconsistent with the Supreme Court's precedent of Heller. Nevertheless, Judge Stephen McGlynn, the district court judge, had to basically follow, with passing references to U.S. Supreme Court precedent, of course, but he had to follow the law of the Second Amendment as articulated, wrongly, mind you, as articulated by the 7th Circuit, by Judge Wood and Judge Easterbrook in a 2-1 decision in Barnett. And Judge McGlynn held a hearing, he held a trial, he issued specific factual findings that basically explained that even under the nonsensical, illegal, not consistent with the Second Amendment and not consistent with Supreme Court precedent, Judge McGlynn had to find that under the wrong standards set forth by the 7th Circuit, the Second Amendment plaintiffs still would prevail. And that's exactly what he did after a long trial with a lot of evidence from experts and other factual witnesses, and basically said that even if you apply the wrong standards set forth by the 7th Circuit in the Barnett case and the Bevis case, guess what? The Second Amendment plaintiffs still prevail, and this law enacted by the state of Illinois against quote-unquote assault weapons, which are really just ordinary semi-automatic firearms, and magazines that hold more than 10 rounds, which are just routine, even if you apply the wrong standard of the Second Amendment, as articulated by the 7th Circuit, the Second Amendment plaintiffs still win. Specifically, Judge McGlynn wrote the following, quote, "Most importantly, considering all the evidence presented, the court holds that the provisions of PICA criminalizing the knowing possession of specific semi-automatic rifles, shotguns, magazines, and attachments are unconstitutional under the Second Amendment to the United States Constitution as applied to the states by the 14th Amendment. Therefore, the Second Amendment plaintiff's request for a permanent injunction is granted. The state of Illinois is hereby enjoined from the enforcement of PICA's criminal penalties in accordance with the relevant statute out there in Illinois concerning bump stocks and assault weapons and attachments, and large capacity magazines, all against Illinois citizens, effective immediately. As the prohibition of firearms is unconstitutional, so is the registration scheme for assault weapons, attachments, and large capacity magazines. Therefore, the state of Illinois is enjoined from enforcing the firearm registration requirements and penalties associated with entering false information on the endorsement affidavit for non-exempt weapons, magazines, and attachments previously required to be registered in accordance with the relevant statute. This permanent, and listen carefully, folks, this is important. This permanent injunction is stayed for 30 days, and the clerk of the court is directed to enter judgment in favor of the plaintiffs. It is so ordered. So after a trial, that is what District Court Judge Stephen McGlynn entered, which is clearly the right answer for anyone who understands A, firearms, and B, understands the law of the Second Amendment and can read the Judge Wood, Judge Easterbrook wrong decision. Nevertheless, Judge McGlynn reached the right result. It's pretty much a no-brainer. But of course, he enjoined it, or I should say he stayed his decision, right? He entered an injunction, but then he stayed it, which means he put it on pause for a period of 30 days to give the state of Illinois the chance to rush to the Seventh Circuit Court of Appeals to get a stay of Judge McGlynn's order throughout the pendency of the appeal of this Barnett case. And unfortunately, we're coming up on that 30-day window right now. We're not quite there yet, but we're getting close. So the three-judge panel of the Seventh Circuit came out and entered an order that agreed with the state of Illinois that Judge McGlynn's order should be stayed pending the appeal, the resolution of the appeal in this case, which I'm just letting you know will likely take 9 months to a year. 9 months to a year is probably when we're going to get a decision on this case. Now, of course, the one curveball before we get back to the specific case of Barnett to keep in mind is the U.S. Supreme Court has up on a cert petition, a pending cert petition right now in the Snope versus Maryland case, Snope versus Brown, which is basically the Maryland assault weapon ban, which, of course, assault weapons is a propaganda term by the anti-gunners for semi-automatic rifles. So if the Supreme Court were to grant cert in the Snope case, which would occur if they're going to do it in January for this coming term, then all these quote-unquote assault weapon cases, including Barnett, will almost undeniably put on pause. No one will do any work at all on these. No judge will just do anything, will read anything, do anything, pending the outcome of the Supreme Court's decision in Snope. And as you know, if the Supreme Court takes the Snope case dealing with the Maryland semi-automatic rifle ban, there's a 99.5% chance that the Second Amendment is going to prevail and that these types of insane anti-gun laws banning some of the most commonly owned firearms in American life today will be struck down as unconstitutional by the Supreme Court because it's such an easy question to decide for the Supreme Court, since they basically already decided in Heller. Nevertheless, let's go back to this particular case, because we don't know what the Supreme Court's going to do, but if they take Snope, then all this case will be put on hold and we don't have to worry about it. But let's go back to this case of Barnett specifically. So now it's in front of the Seventh Circuit. The Seventh Circuit was asked by the state of Illinois to stay the decision by Judge McGlynn, and the court, the Seventh Circuit, issued a 2-page decision here agreeing with Illinois. So in ruling against the Second Amendment plaintiffs in favor of the state, this is what the Seventh Circuit wrote. The state of Illinois' request for a stay rests largely on the fact that this court already has held that the laws in question survive motions seeking preliminary injunctions, signed to Bevis v. Naperville, 2023. A decision at the preliminary injunction stage is not dispositive when the plaintiffs later seek permanent relief. Our opinion indicated some matters that needed further exploration. But the analysis in Bevis shows that the laws have enough support to remain in place pending the resolution or the final resolution of the plaintiff's suit. Now, how dumb is that? So you're a court of appeals in 2023, you say, well, we're going to deny a preliminary injunction in favor of the Second Amendment plaintiffs. We're going to send it back down for trials, get some additional facts, and then we'll go from there. You have an entire trial, a federal district court judge who clearly knows what he's doing, enters a 100-page opinion, lays out in detail why even under this Bevis standard, the Bevis-Barnett standard, whatever you want to call the standard, the Second Amendment plaintiffs win. So the Seventh Circuit says, we don't care. We don't like the Second Amendment. We're still not going to enforce it. We're going to let this law stand. We're just basically going through the motions before we rubber stamp a ruling against the Second Amendment because we don't like it, because we're urban elites from Chicago. That's basically how I read that. We don't care that the federal district court judge did all the work that we directed him to do, and then he did it, and we don't like the outcome. And now we're going to basically say we don't like the outcome, so we're going to pretend it doesn't count. And we're going to make some hooey excuse, which is all that language really is a bunch of hooey. But then it gets even worse. Why? Because then they go on and basically do what we've talked about. That there's no way to get a ruling, in my opinion, in favor of the Second Amendment, and survive an en banc review, by the way, in any of the jurisdictions at the Court of Appeals level that have an opportunity to deal with and rule on quote-unquote assault weapon cases. Why? Because the same nutty states that issue these terrible anti-gun assault weapon bans are the same jurisdictions that give rise to really liberal judges blessed by the liberal politicians in those jurisdictions as a general matter. So you'll see how that fact has been held against the Second Amendment movement with the following point made by this three-judge panel in this case of Barnett. This is what they write, and then we'll talk about it. But you're going to see exactly what I'm saying when you hear what they say right here, right now. The Seventh Circuit writes, quote, every other court of appeals, hear what I just said? Every other court of appeals that has addressed the validity of similar legislation in the wake of NYSERPA versus Bruin has come out the same way as Bevis. They cite to Ocean State, the First Circuit Court of Appeals out of Boston, terrible anti-gun court. They cite to Bianchi versus Brown out of the Fourth Circuit in Maryland and Virginia, terrible anti-gun court. Then they cite Hansen versus Smith out of the District of Columbia, terrible anti-gun court. Deep state, for crying out loud. Nevertheless, this is what the court continues on to say. The Seventh Circuit continues on to say, the laws addressed by those decisions differ in some respects from the Illinois statute, yet the absence of support in the other circuits for the district court's disposition lends strength to a conclusion that the Illinois statute should remain in force until final appellate resolution. This is crap, right? And you know why it is. You don't need to be an Oxford Don to get this. They're citing to your typical anti-gun jurisdictions. The First Circuit out of Boston, the Fourth Circuit out of Maryland and Virginia, the D.C. Deep State Circuit. And they see, all these courts they've all ruled in our favor. Well, of course they ruled in your favor. Where are they from? Who are these judges? What parts of the country are they from? It's no-brainer. We get it. There's no Fifth Circuit question, right? There's no Fifth Circuit ruling out of Texas and Louisiana on the question because there's no quote-unquote assault weapon bans to knock out. You don't get courts down there in Florida or the 11th Circuit, for example, addressing a quote-unquote assault weapon ban, knocking it out. You don't get that because there's no laws enacted in those jurisdictions for a court to address. And remember, courts are always reactive, which means a court can't go out like a legislature and address an issue. A case has to be brought before them before they can act on it. So here you have the Seventh Circuit Court of Appeals talking about, all these courts have already ruled against the Second Amendment. And of course, they cite to the typical liberal courts. This is like saying, Hillary Clinton and Kamala Harris are going to win every election because look, she's won California. Look, she's won New York. Look, she's won deep state D.C. She's won Maryland. Whoa, she's won Vermont. Whoa, she's killing it, right? That's basically what this authority is that the Seventh Circuit is appealing to. That's how to understand that. So it looks like it's legit, and to some degree it is legally legitimate, but in the real world, if you know what's going on, you can tell exactly the games that are being played here. Now, with that said, bottom line is the Illinois laws are going to remain in effect, notwithstanding Judge Stephen McGlynn's ruling in favor of the Second Amendment and all the work he did and all the work that people did in that case. So what happens next? Well, the bottom line is there's going to be a series of briefs submitted over the next many months. There'll be an oral argument probably, I'm guessing, somewhere in the order of magnitude of May. And then there'll be a decision some point, 6 to 9 months thereafter is my guess. Now, Who is this three-judge panel? Well, it looks like there is a three-judge panel that's basically been appointed from the looks of who entered the order. You have Judge Frank Easterbrook, who, of course, is terrible on the Second Amendment, just awful. I don't know whatever happened to Judge Easterbrook. He used to be good. He's absolutely terrible now. I don't know what it is. My speculation is he got bitter when he didn't get the Supreme Court nomination and has gone downhill ever since. But nevertheless, he's a lost cause on the Second Amendment. So just an utter waste of time and space when it comes to Second Amendment issues in front of Judge Easterbrook. Then we have Judge Michael Brennan, a Trump appointee. Obviously, he dissented in the Bevis-Barnett case in favor of the proper interpretation of Heller and how to deal with quote-unquote assault weapon bans. So Judge Brennan obviously is very good news that he's on the panel. So that's one good judge, one bad judge when it comes to the Second Amendment. And lastly, we have who's the person that's likely going to break the tie here is Judge Amy St. Eve. Now, it used to be Judge Diane Wood on this panel, and she was absolutely terrible, but she's no longer on the bench. She's not even a senior judge. So now she's been replaced, apparently, by Judge Amy St. Eve, who was a federal district court judge and was then elevated to the Court of Appeals for the Seventh Circuit by Donald Trump, President Trump. And her record, I would say, is mixed on the Second Amendment. I'm going to be a little generous here. She's certainly not as bad as Judge Wood. That's a fact. There are some anti-Second Amendment rulings she's entered in a couple cases. When she was a district court judge in a case called Redwood, she upheld the gun-free zone laws. But again, that was in like 2015, 2016. So I don't count that as very much because that's before Bruin. Whole different universe applying tiers of scrutiny. So I don't put much stock into that. Then at the Seventh Circuit, she basically upheld a decision to deny concealed carry permit to someone who had multiple felonies. Again, that was in 2021 before Bruin. And again, I don't put a lot of stock in that either. So that doesn't tell me a lot there. But I will say that listening to the oral argument of Vera Montes, I got the sense she was a little hostile to the Second Amendment, but she could just be, pushing the lawyers around, trying to get good answers. And certainly in a case called Wilson, which dealt with a Cook County quote-unquote assault weapon ban, she basically upheld it, but she did so on stare decisis grounds. Basically, she said because the Supreme Court had essentially signed off on the Seventh Circuit ruling in a case called Friedman versus Highland Park, and that was binding case law on the Seventh Circuit. In the Wilson case, in which she sat on dealing with a Cook County quote-unquote assault weapon ban, she basically felt that she was bound by the Seventh Circuit precedent. So again, I don't put a lot of stock into that. So I would say that this is certainly a much better panel than we would have than if Judge Wood were the swing judge. But yes, I can't say that Judge St. Eve has a powerful, favorable record on the Second Amendment in any respect, or with respect to the Constitution in any great respect. Nevertheless, I think there is some evidence that she may be persuadable. We'll know a lot more when that oral argument occurs sometime in the spring. Of course, all this may become a moot point if the U.S. Supreme Court grants cert in the Snopes case. And of course, what we should all be cheering for is that the Supreme Court grants cert in Snopes. That's what we all want, and make all this stuff go away and moot and get the Supreme Court to do the right thing and knock out these quote-unquote assault weapon bans, which is undeniably the right answer under Supreme Court precedent and the history of the Second Amendment, no matter how you look at it. All right, there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to like this video and subscribe and vote for me for the top voices of the Second Amendment for the Gundy Awards 2025. And we'll see you again very soon here at the 4Boxes Diner.
Orders up. Table 2A.